Court will call the third case on the morning docket, 117131, State of Kansas versus Cecil Megerson. Counsel?
Please support Jeff Black and Cecil Megerson, presently here.
May approach. Thank you.
Judge, may I reserve 3 minutes, please?
3 minutes is granted.
Thank you, Judge. Good morning. Thank you for this opportunity to present Mr. Megerson's case this morning on direct appeal. The court just heard a little bit of evidence regarding this particular case. It was a separate trial, but a co-defendant nonetheless, so you probably have an idea of what the basic facts were. But these were separate trials, and I would probably take deference to some of the comments that were made about my client, Mr. Megerson, and his involvement, or lack thereof, in these series of robberies that were involving 3 individuals brandishing firearms during some robberies in Kansas and Missouri, ultimately culminating in the shooting of a gentleman who was working off duty as a police officer, not at the time, but he was off his shift and he was shot during one of these robberies. The evidence in the case was highly circumstantial against Mr. Megerson in the case, and I think that if you review the testimony from all the eyewitnesses that were involved in these robberies, and they were all called to testify, which is one of the issues that I'm going to get to here in a minute, but none of them could identify Mr. Megerson. Ultimately, the police in this particular case got to, I believe, Mr. King's residence at the time through some fingerprint evidence that led directly to him. And when they got to that location, they found significant evidence at that point that Mr. King was involved. Even some statements that were made by Mr. King contemporaneously upon that arrest were quite menacing and suggestive that he was involved in these particular crimes. And one of the interesting things that was brought out in the trial, I think you heard, I believe it was Officer Dumdovich, when it was arrested, he was being asked why Mr. Megerson was arrested at that time, because he wasn't being sought, and I think his statement was something along the lines of, well, he was the 3rd black man in the room. So inferring, why not arrest him at that particular point, because they knew they were looking for another African-American individual. But there was a massive amount of evidence, DNA evidence, fingerprint evidence that was collected regarding Mr. King and Mr. Bowser, but nothing that really tied Mr. Megerson into the crime. What ended up getting to him was there was some evidence that was taken from a cell phone that I believe the trial has helped to pinpoint his location during some of these incidents, and some jail phone calls that were also an issue that we brought up on appeal, and why the state was allowed to present those despite the lack of foundation. But getting back to that cell phone, I think that's one of the bigger issues on the appeal, and it was brought to the court's attention before this evidence was presented and objected to at trial. But the warrant that was obtained, we believe, was obtained illegally at the time and just rubber stamped by the magistrate or the judge in, I believe it was Clay County. And I think the reason that we were asking for a warrant in Clay County to get anything in this case was because that's where the cell phones and the evidence were actually located at the time at the crime labs. And there was a hearing on this particular warrant, and during that hearing, the investigator, who I believe was David Foster, admitted that probable cause was not presented for the phones themselves. The information that was provided may be erroneous, or for whatever reason was, this was a piggyback warrant they were trying to get, but the evidence I believe that was initially presented to them was involving the search of a vehicle and the search of a residence. And he was questioned about that by counsel at the motion hearing, and he acknowledged David Foster acknowledged anyway that in his own affidavit he did not put the information that would have presented probable cause to get the warrant for the phones. And I think in this particular instance, if the court determines that this cell phone was obtained through some warrant that was not legitimate, I think you have to determine how does that impact this trial. And in this particular case, there were some pictures, I believe, that were taken from that phone that showed Mr. Megerson drinking some of the alcohol, I think, that was allegedly stolen during one of these crimes.
Counsel, I'm sorry to interrupt, but where is the affidavit or the probable cause statements in the record in this case?
Well, they were cited in the brief, and I believe that I'm gonna have to get back to you on the exact location of that, but the statements as far as the lack of probable cause and what was actually presented, that is...
But don't we have to look at the warrant that you're alleging is defective? Don't we have to look at the affidavits that support the warrant in order to determine its constitutional adequacy? Or are you trying to base this whole case on this other statement by the officer in a transcript?
I am. Well, I'm just basing the argument based on, and I think, and I don't know, to answer your original question, I don't know that that portion of the record was memorialized at the time. And I don't believe it's on the record. What we're looking at is the actual hearing that the judge in Wyandotte County had to determine whether or not these phones were obtained legitimately and through an appropriate warrant. But the record is pretty clear in what he says, because he's asked twice about it, and ultimately he's asking, did you provide a supporting affidavit for probable cause for these particular phones? He acknowledged that he did not. He did not present these things. So that's what the argument's being based on, is just exactly what the officer said and acknowledged under oath. And I think that the evidence that was taken from that phone was really the only significant evidence against Mr. Megerson in the entire case, because that evidence itself also, I believe, had GPS location information that was used against him and used to ultimately convict him in this particular case. But beyond that, there really was an entire void of evidence. The other big component of the evidence that was utilized was the information from these jail phone calls that they obtained, which were obtained through a system, I believe it was called Paytel, the Paytel system. They're the ones who logged this for the actual Wyandotte County Jail. It's a system that's not maintained by the Wyandotte County Jail. They're familiar with it because it's their jail that's being used in. But the information from those jail phone calls at trial anyway was presented by detectives who were really just making an ID from a computer screen. They, I think, rightfully acknowledged they didn't maintain the system, didn't really know that much about it other than how to use it. But they were not, I believe, presented as proper foundation to present this information, and certainly these identifications of people that were on the calls. The calls in question provide us with the additional limited evidence against Mr. Megerson. When I say against Mr. Megerson, really the evidence that supports him being associated with these gentlemen at all, really, because I think the call in question was really between Mr. Megerson and his girlfriend, and he suggests something to her like she needed to get rid of 2 packs in the house. And what that was referred to in closing arguments, I think, is that the 2 packs that he's referring to are cigarettes that were also stolen in one of these robberies. And ultimately, I think the same type of cigarettes that led the police in the first place to the other co-defendant who essentially admitted to the crimes, Mr. King. And so when the police searched Mr. Megerson's residence, they found nothing. They didn't find the packs, they didn't find clothes, they didn't find a weapon, they found absolutely nothing. And so not only did they try and attribute that these 2 packs were missing, I believe the closing arguments the prosecutors also tried to suggest to the jury, because of these phone calls, because of what he's doing in these phone calls, that's why we don't have any evidence. That's why when the police got there, it was gone, because he's instructing his associate there to get rid of these things. So,
Counsel, I have a question about your sufficiency argument.
sure,
It's limited to the attempted capital murder, right?
essentially, yes.
Okay.
And speaking of, I mean, that was, and I guess I would adopt some of the comments that you just heard in the co-defendant's case here a few minutes ago. It was a situation where there was no evidence that I believe was presented, although it was a separate trial than what you just heard about previously. In Mr. Megerson's trial, I don't believe there was any evidence presented, much like Mr. Bowser, to suggest premeditation, intent to kill, plan or conspiracy to commit any type of robbery or murder. That just didn't exist. Again, the record's completely void of anything that suggests that any of these things actually existed. There was, I think, as far as the evidence that was presented, beyond what I just told you, the only other piece I think that might be on the record is a glove with some DNA that was attributed to Mr. Megerson's, and I believe that glove was found in Mr. King's car.
That glove was on the hand of one of the people who shot at the officer, right, or the deputy?
I don't believe that the glove that the DNA was found on, I don't believe that it was used in the robberies, is my recollection of the way the transcript reads. But that was the only other evidence than what I just told you, I think, that was presented against Mr. Megerson at the time of the trial. And again, the search of his home provided no such evidence, no such clothes, no weapons, no packs. The other evidence that I felt was particularly...
Counsel, if you don't, excuse me just a minute.
Sure.
I just want to back up a second before you move on. You said there was no evidence of premeditation or intent to kill. The state's allegation was that your client was one of the shooters, right?
That was their allegation.
Okay. And that was based on video and association with the other individuals, et cetera. Can't the wounds that the deputy suffered and their relative likelihood to be lethal or not lethal be evidence of an intent to kill?
Well, certainly, I guess after the fact, I think the court probably needs to focus more on specifically Mr. Megerson, his involvement in that particular act, or being with one of the individuals and committing some overt act that would suggest that he did intend to kill the deputy in that particular case.
Was the evidence specific to each individual who shot? Which wounds were caused by which individual?
Well, and I apologize, it has been a long time since I reviewed that portion of the brief, but my recollection of that specific part that you're referring to and the evidence that was presented on that was that the inference was made that Mr. King was the one who was primarily involved in the shooting of the deputy, and that seemed to be some sort of a spontaneous act where the other two were not necessarily a part of it at the time. So again, when you're talking about conspiracy and the intent and premeditation, I think that's different than maybe what Your Honor just suggested a second ago. I think they're two separate things. And the majority of the evidence that was presented in this case too, and I'm sure the court's quite familiar since we have two cases this morning on the docket, with the evidence that was presented. It was mostly presented from crimes that were uncharged and unproven. These are prior bad act evidences. That evidence is just, it's scary. I think that it seems to change the burden of proof from being beyond a reasonable doubt to a preponderance of the evidence, because these are unproven crimes. These are prior bad acts you're suggesting that Mr. Megerson did, and it seems obvious, at least.
Is it your suggestion here is that it's not the admission of 6455 material that you're complaining of, it's the volume of it, it's the quantity of it that exceeded over 50% of the trial, That's your problem here. And do you have any cases or anything you can point to where we have analyzed that issue in the terms that you're suggesting, that there's some sort of tipping point where the volume of the evidence exceeds the case in chief or the crimes charged, if you see what I'm saying?
No, I did.
And where is it? Where is it? Because I think that's your point, is that it's the volume of it. There's too much. Do you have any cases for us where we discuss that, or where it becomes, just by the sheer volume, it becomes prejudicial?
Beyond what I offered, no, but I think it's a significant point. I did raise it in the brief, and that's almost all the evidence you heard did not take place in Wyandotte County, Kansas. It was all evidence from things that had happened in various locations in Missouri. And so, given the fact that Mr. Megerson was never convicted of any of those robberies, these are things that were presented to the jury as if he had. I think that the reason that it was used was not to show, in this case, I guess it would have been proper if it was being used to show some sort of specific plan.
It was used for identity, and didn't everybody agree that that was appropriate? I think you did too.
Well, I'm not sure that I did, but that's not the way that it was used at the trial, though. As far as I can tell and read in the transcripts, I mean, it was essentially used to show that they committed these crimes. They must have committed this last one, and I think that's the reason that you normally would not allow that type of evidence. It was certainly highly prejudicial. How did it impact this jury? Well, they heard it over and over and over again, about unproven crimes that my client did not have the benefit of a trial on.
There was a limiting instruction, right? And it talked about identity, didn't it?
Yeah, and there always is. And I guess I'm not entirely sure that cures the problem in this particular case. Just, again, referring back to my brief, the volume of it, and I think the way the judge just kind of suggested, it was so much that the limiting instruction, I don't think, cures the problem that we have.
What's the specific error then? Because, as I think my colleague suggested, I don't know that we've ever said volume of 6455 evidence constitutes error.
No, I think the evidence itself is the error, and maybe I'm just misspeaking and not artfully, certainly.
You're saying it was inadmissible?
Yes.
And specifically, can you articulate why it was inadmissible?
Well, because it was more prejudicial than probative. And again, referring back to my brief, I think that it just completely changes the burden of proof at trial, whereas the state doesn't have to prove these things beyond reasonable doubt to any particular jury. Yet they come out of that hearing believing that's exactly what happened. Regardless, if there was no other questions, I guess I would cede to my colleague. I see my time is run.
Questions? Thank you, counsel.
Just one question on that, on the telephone calls. Do I understand all that came in through the testimony of a detective repeating what he had heard on the tape?
Yeah, that's how it was used, I think.
And the tape itself was not admitted into evidence, or a transcript was not admitted? Or was it?
I don't believe so. I believe that, and I'm sorry, that I know that Sherry Anderson testified, and she was supposedly trying to lay the foundation for the calls for the jail system. I can't remember the specific detective that was testifying at the time, but he was allowed to present evidence to the jury. I don't believe there's any transcript that was presented to the jury.
Did the detective testify that he was acquainted with the defendant, knew his voice, and that he recognized this as the defendant's voice?
Well, right. So my understanding, the way he testified, was that he understood that to be his voice, and he recognized it because of what he had heard on the calls and what he knew about the system itself. I don't think that his testimony was that he knew him individually and knew his voice.
He's not somebody who had interviewed the defendant before?
That's my recollection.
All right.
So what is the nature of your foundation objection exactly? That somebody from the company that
Right. So
makes the system needed to testify?
Right. The crux of that is that somebody who actually maintained the system could identify and attribute a specific call to a specific inmate should have been used.
Okay, is that the only foundation objection you're making, or
Yes.
challenge making? Thank you.
Other questions? Thank you, counsel.
Counsel, Madam Chief Justice, may it please the court, Assistant District Attorney Wyandotte County, Daniel Obermeyer for the state. I'm going to discuss the facts of this case more than I did in Mr. Bowser's case because this case presents questions of sufficiency of the evidence and also whether or not the district court erred in admitting 6455 evidence for the purposes of identity, plan, and intent. Between February 27th and March 4th of 2015, there was a series of robberies in the Kansas City metro area. These were all three affected by armed, hooded, gloved, masked individuals. This ultimately culminated in the attempted capital murder of Deputy Scott Wood at the 7-Eleven in Kansas City, Kansas. I'll take these events as they present themselves in chronological order. The first robbery occurred at the Don's Liquors Market on February 27th, 2015. In that case, there were three individuals wearing dark clothing, masks, gloves again. They were carrying firearms. One of them was a Mac-style weapon, semi-automatic weapon. The other was a revolver. Another was another semi-automatic weapon. The individuals, they had distinctive gloves. One appeared to be wearing a set of gray gloves. Another appeared to be wearing a set of gold gloves with dark gloves with gold lining, and another had some black and white Easton batting gloves. They threatened the cashier, took money, and then left. The second robbery occurred some days later on March 3rd in the evening hours at Family Dollar located in Kansas City, Kansas. There, again, it was the same testimony presented. These three masked individuals, similarly clothed, came in with firearms threatening. From the Family Dollar, what's of note is that the robbers took some packs of Newport cigarettes, and these Newport cigarettes had on them a tax stamp designating from what batch they came from, so that they could be tracked later. The next robbery took place later that night at Shamrock Liquor Store located in Kansas City, Missouri. Appears to be the same three individuals as wearing the same clothing style as at the Family Dollar. There's a difference. One of the individuals has sort of a face mask that has a Mizzou tiger on it, and in that case, and that defendant, that suspect there was wearing the gray gloves. From the Shamrock Liquor Store, the robbers proceeded to take some bottles of Remy Martin, some Patron, and some 1800 tequila. Again, these also had numbers that were able, or tax stamps that were able to identify as coming from that store, being consistent with coming from that store. The third, fourth robbery, was later in Kansas City, Missouri at Kick 66. That occurred in the early morning hours of March 4th at about 12:46. There in that video, again, appears to be the same three individuals as at Shamrock and as at Family Dollar. Guns drawn, consistent guns. And then finally, at the 7-Eleven, again, it appears to be the same three individuals as at Family Dollar, Shamrock, and Kick 66. The only distinctive difference in clothing at the Don's Liquor Store is one of the defendants was wearing a gray two-tone hoodie, and that suspect later appears to be wearing a black hoodie with a gold eagle. Now, because these were masked individuals and gloved, obviously it posed a challenge for law enforcement as how to identify him. They were able to identify these robbers because behind the Kick 66, there was one of the forensic officers from Kansas City, Missouri noticed that one of the robbers propped open the door with a fence post, and he thought maybe this fence post is from an area nearby, so they go, it's an area I believe is behind the Kick 66, and there they find what appeared an unopened package of Newport cigarettes and a black makeshift mask is how it's described. They do they find a fingerprint that matches Dyrone King on the Newport package From there, police go to Dyron King's house, and there is also Cecil Megerson and Charles Bowser. And parked outside of Dyron King's house is Charles Bowser's Lincoln LS, black in color. And inside of that Lincoln is found gloves that appear to be consistent with the gloves used at these robberies. And those gloves are later tested. Highly summarized, the black glove with gold has Charles Bowser's DNA on it. One of the gray gloves has Cecil Megerson's DNA on it, and the black and white Easton batting gloves have Dyron King's batting glove on it. And I've gone into a lot more detail, and I've taken up a lot of my time going through these facts because it's important for the court to consider for the appropriateness of the 6455 evidence.
And although you're headed towards that, just so you're talking about facts, what do the facts and tell us in terms of color of glove and shooter? What can we tell from that?
The state, so also for the shoes, one of the robber wearing the black and white Easton batting gloves had some gray boot-style Nikes on. The robber with the gray gloves had some black Nike Air Max shoes on. Cecil Megerson was arrested wearing those black Nike Air Max shoes. The state pointed this out in a presentation of the evidence to the jury.
Did you ask about shoes or shooter?
Shooter.
Oh, I'm
The
so
shooter.
sorry. I'm so sorry, Justice
That's
Lickard. I
okay.
misheard you.
But there was dropping of blood on one of the shoes.
Yes, on the gray shoes, there was blood from Brendan Fox, where he was one of the victims at the Shamrock liquor store.
So that ties King, not this
That
defendant.
ties King, yes.
So,
Okay.
yeah, my question was what can you see in terms of what gloves the shooter was wearing?
Oh, okay. So going back to the 7-Eleven, it's the short robber wearing the gray gloves, and he has the revolver. That's in the 7-Eleven video. That's the state's theory. That person is Cecil Megerson. And then you have the larger person wearing the black and white Easton batting gloves. That person under the state's theory is Dyron King. And I don't believe that this court has before it in this case the exhibits that were presented to the jury. But I mean, I can't say that this is exactly the same because I haven't had an opportunity to review that. I was not the trial attorney, but I'd be shocked if this wasn't the same 7-Eleven video as presented itself in Charles Bowser's case, and the court does have that record. So my review of that 7-Eleven video and my recollection of the testimony in Cecil Megerson's case is that the Megerson gloves person has the revolver, that as they're leaving the 7-Eleven, he does a sort of lean in and shoots, apparently taking aim at Deputy Scott Wood's head. So in terms of the sufficiency of premeditation, if the state has proven to the jury that the person wearing this clothing is Cecil Megerson, then I think that there's a very strong argument that yes, Cecil Megerson personally possessed or had premeditated killing Deputy Scott Wood, just because of the way he's aiming and the way he's presenting himself on that. There were also threats made to Deputy Wood and to Daniel Bayer, the clerk at the 7-Eleven. I believe Deputy Wood specifically testified that he was not to move or he would be killed. As I don't know if I noted it in this argument, but Deputy Wood, when confronted with the robbers, he assumed a prone position on the floor so as to show that that he was not a threat to them, that he was not trying to obstruct them. So in terms of sufficiency of the evidence for the premeditation required for the attempted capital murder, I would submit that the evidence presented adequately shows that. Unless there's any other questions on the sufficiency issue. Okay. One more thing I would note on the sufficiency issue. When one of the text messages from Megerson to, under state's theory, Dyron King, he texts, "I need them 357. Now, the Deputy Wood's blood was found on a .357 revolver, which was located in Dyron King's room. So that also shows, I mean, that's evidence that this is the weapon of the attempted murder in that case. And we have Magerson, who knows about that and is requesting it. Moving to issue 2, whether there was substantial competent evidence to support the district court's decision not to not to suppress the contents of Cecil Magerson's phone. I think that either Mr. Leiker is misreading the record or I am, because my reading of the testimony from Officer Foster from the Clay County Sheriff's Department is that the only omission he made was on the face sheet of the warrant. He said that he included a certain warrants and affidavits, but he did not note, I just want to be clear, he did not note that he included the affidavits, but his testimony was that he did include the affidavits. The district court heard that testimony and it found him credible, and based on that found, and it also had before it State's Exhibit 1 from that hearing, which again is not before this court. And on reviewing that, the court found evidence that the Clay County judge, Judge Angels, had been presented with sufficient evidence to find probable cause for the warrant.
And is it right that we do not have those affidavits and warrant in our record?
Well, it's not the state's burden to furnish.
Right, I'm just asking you if you agree with me that we don't have those things in our record.
Yes, I did not see them. So,
Could you move to the 6455? You're almost out of time.
Yes.
And my question isn't the nature of the relevancy of the material. It seems that everyone agreed identity and plan, all of knowledge was appropriate. But it's the quantity question that I asked counsel about too. Isn't there a point where it does become that the trial's more about the 6455 material than what's actually before the court on the charges? And when you reach this kind of level that's over half of the evidence, should we be concerned about that, or how do we weigh that? I mean, you can imagine a situation where there's a single charge, there's one witness who testifies about the charge, and then there's 7 or 8 6455 types of. And who's on trial? What's on trial is a question I would have. Is there confusion in this case about that?
So just so I understand your question correctly, Justice Rosen.
Yeah, it's basically can quantity become prejudicial to the point where it actually is prejudicial.
I have to fall back on, all incriminating evidence is, prejudicial. The question whether it becomes unduly prejudicial. And if the state's, this isn't propensity evidence. I don't read this ever as being propensity evidence. You have extremely similar individuals that the state can tie, can use physical evidence to tie all of them to these scenes in Kansas City, Kansas. And the fact that it's also occurring in Kansas City, Missouri is highly probative.
Oh, I understand that.
Okay.
Yeah, it's not the propriety of it. It's just the volume of the sheer volume. This case could become more about the Missouri cases than it does the Kansas cases.
Well, I mean, if sheer volume is the issue, then I don't think this is the case where you have to worry about sheer volume. And there's no statutory prohibition on it.
I understand.
Well, isn't the question that there needs to be an objection because the evidence is cumulative? And there was no objection in this case. So there's no problem. I mean, there may be a problem, but it's not appealable.
There was an objection to unduly prejudicial, though, wasn't there? Wasn't there some sort of preserved objection?
I believe so. It was, if my recollection is correct, it's in Volume 8 of the record. It was a hybrid, unduly prejudicial, and it's more than 50% of the case. That was the basis of the objection. It wasn't a cumulative objection, though. You're right. But honestly, I think that the state has to present this evidence to the jury. I mean, first off, because, well, this could be in another sense exculpatory evidence, because defense counsel can get up and say, well, you have all these other robberies happening in roughly the same time, and that's not before the jury, is it? I mean, that could be opening the door, but I think that that's proper that the state introduce that in this case in chief.
Counsel, as I recall, there was at least one of the charged crimes on which this defendant was acquitted. Is that correct?
Yes, that was the aggravated robbery of Reginald Jones. He was one of the victims at the Family Dollar.
Okay. So obviously the jury kind of picked through the charges carefully.
I think that that's clearly what that shows, yes.
Okay.
I would just, I'm running out of time here. In conclusion, I just ask this court to affirm the convictions. I don't believe that defendant has showed that there was one error in this case, so that I would argue that cumulative error does not apply. I think that the jury considered this evidence, the defendant received a fair trial, and I would ask that this court affirm his convictions.
Any questions for counsel? All right, thank you.
Thank you.
Mr. Lecker, you reserve 3 minutes.
Thank you. I might not eat it all. I just want to point out and touch on a couple of things that I just heard. And again, I think there was some discussion about it, but on the warrant issue specifically, the testimony, and I don't think that the state and I am saying the evidence is really that much different. I believe the actual document does not exist as far as we know in the record. What was in front of the court on that particular day, though, and what the investigator from Missouri was testifying to, specifically acknowledged that the appropriate information was not contained in his own affidavit that he swore under oath and presented to the court for the search of these cell phones. And I think the additional information that was maybe being referenced was the investigator was saying something in the line like, even though you don't see it here, I included it elsewhere. I had attached these things elsewhere, and that's kind of where I guess the credibility argument that was being made comes in. As far as the evidence that was collected, and this was also discussed a little bit earlier by the appellee, the blood evidence and the evidence that was actually collected to the clothing that was collected, those tied in Bowser, they tied in King. None of that evidence, I believe, tied in Mr. Megerson. The only evidence that was discussed earlier when I was talking to you on my direct, and that was that they did find a glove. There was DNA evidence on it, but I don't know that that particular glove had blood or any evidence of a crime on it. It was just a glove found in a car, a vehicle that was owned by a relative of my client. And
it was the same make of glove that could be identified in the videos.
It was a black glove, and I guess, yes, it would have been similar in nature to what was seen on the actual videos itself, but I guess the distinction I was trying to make is that the other clothing that was collected and used against Mr. King, for example, had blood from the victims in the case, in addition to his own DNA contained in it.
So it may not have been as strong, but it wasn't nothing.
Well, I guess that's for interpretation. To what level, nothing. How far you go on something like that. So, and those are the only other points I wanted to touch on. In conclusion, I would ask this court respectively overturn the convictions of Mr. Megerson, and thank you. It's always an honor sitting before this court.
Thank you, counsel. We will take this matter under advisement.